November 29, 2018. It is a normal Thursday morning, and 26-year-old Elisa Thompson is at her job with Conduent, where she works in its call center. After finishing her morning shift, she goes on lunch break. She exited the building where Conduent is located and walked to her vehicle in the Hillside Business Plaza's parking lot. She entered her vehicle and sat there while waiting for her boyfriend, Marcus Moore, also a co-worker at Conduent, to return from a nearby Publix where he was picking up lunch for the both of them. While she was waiting, a man loitering in the parking lot, Reginald Gibson, approached Elisa with a knife. He forced her into the passenger side of her vehicle and assumed control of her car. He quickly drove away with Elisa in the passenger seat. The events that followed are disturbing and involved S.A., attempted murder, and eventually cold-blooded murder. Why was Reginald Gibson in this isolated business plaza's parking lot? Why did he have a knife with him? Was it all just a bad random coincidence? To answer these questions, we must rewind time to a few days earlier so we can understand what was going on with Reginald Gibson and why he was loitering in the Hillside parking lot on the day he kidnapped Elisa.
Reginald Gibson is the ex-boyfriend of one of Elisa's Conduent co-workers, Shaterika Doe. Please note that we have changed the last name of this lady to protect her privacy. Reginald and Shaterika have a history, including a child together, a little boy. Sadly, while Shaterika was pregnant with her child, Reginald was being sent to prison for dealing drugs. He was eventually released, and Shaterika gave him a chance. He moved in with her and their child. During this time period, he had driven her to Hillside Business Plaza, where Conduent has its call center. The relationship, however, began to rot, and Shaterika broke up with Reginald. He did not take the breakup very well, and he was enraged when he found out that she was communicating with someone else. The crazy came out, and he began to stalk and harass Shaterika.
November 26, 2018. Reginald called Shaterika, threatening and harassing her. November 27, 2018. He heads over to Future Steps Academy, where their child was during Shaterika's work days. Reginald is one of the names under pickup, and under the pretense that he wanted to spend time with his child, he was allowed inside. Instead of playing with his son, he looks out the window and waits for her to arrive. He grabs their son and walks toward her vehicle using a knife and her son as the lure. A struggle ensued, and she got cut. He drives her car away with her and the little boy inside, the trunk open, the boy screaming. She manages to throw the knife out the car window, but it did not stop him from kidnapping and holding them hostage at the same house he would later take Elisa. He stole her phone, forced her to give him the passcode, and went through all of her messages. She feared for her life, as he threatened to kill her if she tried to escape, after already striking her. Eventually, Reginald's cousin, the primary resident of the home, arrived, and Reginald lets Shaterika and their child go after she promised she would not contact law enforcement. An employee of the daycare center where Reginald kidnapped Shaterika and their son had heard the commotion outside. She went outside and saw the vehicle leave in a reckless manner with the trunk open. She called Shaterika but got no answer. She also called Shaterika's mom and reported what she saw. Later that day, another employee who had seen Reginald drive out of the parking lot in a reckless manner found a bloody knife in the parking lot in an area where the vehicle had been driving through. Police were called immediately and took possession of the knife, which was bent and seemed to have dry blood, as evidence. That evening, Shaterika called the female daycare employee who had tried to call her, and Shaterika told her that Reginald attacked her. The employee notified police, and police immediately contacted Shaterika. Shaterika met with police at the location of the kidnapping, the daycare, and she gave a detailed description of what Reginald did to her and their child. Between the date of her kidnapping and the moment Reginald kidnapped the decedent in this case, Elisa Thompson, in the parking lot of Sheterica's place of employment, Sheterica had been hiding from Reginald. Furthermore, she notified her employer, Conduent, about what happened by talking to the call center manager, Miss Bonner-Rowe. According to Sheterica, she gave Miss Bonner-Rowe enough details for her to know exactly what was going on between her and Reginald Gibson. Neither Miss Bonner-Rowe nor Conduent did anything with this information. No extra security measures were put in place. No security assessment was done about the situation. No guards were hired. No notice was given to other employees or tenants of the business plaza about the potential that a dangerous man with bad intentions, Reginald Gibson, may come onto the property. No information was shared with the landlord about the specific threat from Reginald Gibson, and therefore the landlord also did not make a security assessment, add security measures, or did anything in response to what happened to Sheterica, or in response to the potential that a dangerous man, Reginald Gibson, would come onto the business plaza looking to again kidnap and harm Sheterica. So now let's go back to Thursday, November 29, 2018. Elisa goes on her usual lunch break, unaware about what happened to her coworker Sheterica. So Elisa goes outside, heads to her vehicle, and waits there for her boyfriend. Other employees had already noticed Reginald Gibson loitering in the parking lot, but did not realize the danger he presented. Reginald approaches Elisa's vehicle with a knife. He gains entry and drives off at a fast rate of speed, with Elisa scared on the passenger side. Elisa's co-workers in the area see this, but without knowing anything about Reginald or what he did to Sheterica 2 days earlier, they don't realize they just witnessed a kidnapping by a very dangerous and volatile man. Even Elisa's boyfriend sees Elisa's vehicle, leaving at a fast rate speed, and another man driving her vehicle. But he does not associate this with a kidnapping, thinking that instead there may have been a family emergency. Unfortunately, the boyfriend was dead wrong. Elisa is kidnapped. He takes her to the same house where Reginald held Sheterica hostage. He gets her to give him access code to her phone so he could later use it to reach out to Sheterica. Reginald then sexually molests her and tries to kill her. He puts her unconscious body in the trunk of her vehicle and drives off, looking for Sheterica. At some moment, he hears moaning from the trunk of the vehicle, so he stops, opens the trunk, and finishes the job. So as you can see, there is a reason why Reginald was in the parking lot of the place where Elisa worked. There is no doubt that Reginald was enraged and wanted to harm Sheterica. There is no doubt that he knew that he had already committed a crime that was likely going to send him to prison for the rest of his life, the kidnapping of Sheterica. Therefore, Reginald was a very dangerous and volatile man. Elisa, for him, was an opportunity. She could provide him a vehicle that he could use to look for Sheterica. She could provide him a phone that he could use to contact Sheterica. And he could use her body and dispose of her. Since he had nothing to lose, for him the life of Elisa did not matter at all. Elisa's murder had a deep impact on her children and her family, and all of those who loved her. Reginald's case is still pending.
First, we're going to look at a follow-up police interview with Sheterica Doe. Please keep in mind that because the case against Reginald is still pending, that under the law, at least, he's presumed innocent until a jury finds him guilty or a resolution is reached in the case.
Sit this right here so I can pick up good. And unless that bothers you right there, I'll sit it somewhere else. I should be sitting there staring at it, trying to. All right. When I last talked to you, was at your place of employment. This is when you came up. We weren't even there to see you. We didn't even know. Myself and the other investigator didn't know about your case with Mr. Gibson and how it was related until you came to told us about what happened at the daycare. You shared the video footage with us that your friends had sent you, or they linked to Facebook, and that's kind of what got the ball rolling. One of the questions I had about your case that happened, on that Tuesday at the daycare when he abducted you, I know he carried you back to his house. Your finger was cut already at the daycare, right?
Mm-hmm.
How is it unwrapped now?
Well, I got the stitches taken.
How many stitches were in it?
4.
Okay. All right. Was it bleeding severely?
Mm-hmm.
It was. How much? I mean, was it still bleeding when you got to his house?
Mm-hmm.
Okay. All right. Where did y'all go inside the house?
To the room.
To his bedroom. Did y'all get into the bed for any reason?
To the who now?
Did you get in his bed for any reason?
He put me on the bed.
Okay.
So I'm gonna lay down.
All right. Was your finger still bleeding at that time? It was.
It was bleeding all the way till I got to the hospital, basically.
Okay. All right. Would there be any reason for the blood from your finger to be like on the walls? I'm trying to determine like if it's your blood we're finding or if it's Miss Thompson's blood.
Yeah, it was blood everywhere. Even on the floor it was dripping. When he made me lay down, I tried to, get him off me so it could have splattered.
And the knife he cut you with was a kitchen knife, right?
Mm-hmm. It looked like a kitchen knife.
Okay. All right.
But I snatched it, out.
Right. That's when it cut you. So you snatched out. Okay. Did you leave any clothing items there or any jewelry there?
Clothing.
What kind of clothing?
I had on some, I think it was gray, black, and white, like the jogger type pants.
Mm-hmm.
A shirt, because he made me put on his pants, and he made me put on his shirt.
Mm-hmm.
Okay.
What about undergarments?
I believe it was a bra I left.
You remember what color it would have been?
Hey, bud.
You can get some cookies. We can take a break and get some cookies.
Yeah, why don't you tell me where I'll go get it for him.
Go with Investigator Lewis and pick out whichever cookie you want. Some Oreos?
Mm-hmm.
You probably need some milk to go with those.
What's your name, dude?
Okay.
You tell me your name?
And you told me, I guess, whenever his roommate came home, his cousin came home, he kind of started acting normal. He let you leave the house. So you're able to leave in your car.
Like 2 or 3 at a time.
So, did his cousin see you in the house, or he did not?
Mm-hmm.
Okay. All right. All right. And then fast forwarding to the case with Miss Thompson. I'm trying to determine if he knew Miss Thompson at all.
I don't know.
Mm-hmm.
Yeah, I don't know. Because I've been hearing they were dating, then I heard he didn't know her. I don't know.
Can you tell me, and I hate to do it, but can you tell me who told you that they were dating? Because I'm going to have to go to those people.
The report, he said.
The report? Okay, is that where you heard it at?
Mm-hmm.
Was from the report? Okay. No,
Then on Facebook.
It was on Facebook too? Was it on Facebook before the report came out or after the report?
It was on before.
Before? Okay. Do you remember who on Facebook said they were dating?
It was so many statuses. I don't know.
Okay. Is there anybody that would know? 'Cause how well did you know Miss Thompson?
We were co-workers. She would speak every night, like off and on, but we never hung together or anything like that.
Did you have her phone number? I think I already asked you this, but
yeah, I didn't
y'all didn't talk on the phone or anything like that? Never hung out after work? Okay. Is there anybody that you can think of that would know if they... It might not even been a dating relationship. Maybe it was just a sexual relationship. I don't know.
I mean, maybe one of the co-workers would. I don't know. Because I don't know any of her family.
Okay. All right. And did he ever give you any indication that he had a relationship with anybody at your job? Okay. All right. Do you know anybody else that he was involved with, like female-wise?
No. Because he was always harassing me. Like, you can't have a girlfriend. You keep harassing me. So.
Yeah. All right. That might be all I have. That was it. I'm just looking for some link between him and her for the most part, and then just determine if any of your blood was still left in the house.
Yeah, I know it was on the floor. It was on the bed. and it may have splattered on the wall. Like when you walking into the right.
Mm-hmm.
I think I seen some blood there.
This would have been like up above the bed, maybe.
Above the bed?
Yeah.
I don't think above the bed.
Don't think it was in above the bed? Okay. Alright. Okay. Yeah, I think that's it. You got any questions for me? One of the things I do want to ask you is your mom. What's your mom's name?
Angela Robinson.
And what's her phone number? And I know that she's already spoken to investigators. There's so many people working on it. I'm just trying to make sure I've got correct contact information. Where was she? Where was she at? Where was she going to? I guess when she saw him. Remember what time of day that was that she said she saw him?
Maybe around that picked my son up. Maybe like between 3 or 4.
Mm-hmm.
She was leaving. She said she was leaving out the neighborhood, and he was coming in. And then when he saw her, he made a U-turn and got behind her.
And she was leaving to pick your son up? Or where was she going?
I don't know where she was. But she did go down North Carolina.
Does she normally keep your sons on your son on that day? Friday?
Because I didn't ask her to go get him that day. Because the detectives, they followed me to go get him. So she didn't have to get him.
Did you tell me you remember what color bra that you might have left behind?
It could be black. Yeah, it could have been black.
Any jewelry?
No. Well, I had a diamond earring, like a clip-on diamond earring.
No hoop earrings, though, right? Okay. Why did you make you change clothes?
It was blood on my clothes.
Can you show me the text message that he saw that let him know that you had a friend on Texas Street? Now, how did he know that you were? Here, hang on. What does he text? Is this from his number or from?
I don't know. The detective made me call that number back.
Oh, this is the fourth. Did the detectives get pictures of this?
Mm-hmm.
They did. You remember which detective? I know that you made a call to him. And he didn't answer, right?
No.
It was some other dude.
I forgot the guy name.
Yeah, we talked to him. Yeah, I talked to him. And how did he know to send you a message that said the bricks? Was there something else that he saw on your phone?
He read the text message me and my friend had.
Can you show me that one? How did he know from that message that the guy lived in the bricks?
I don't know.
Okay.
I don't know. Because I'm like, there's more than one project.
Yeah. I mean, if it's not too personal, if you don't mind me just looking at it, so I can try to figure that one out. I mean, he could have found out from a mutual friend, right?
Yeah.
That
He knew a lot of people, too.
that you were seeing some guy up in there.
Mm-hmm.
That's probably what it was. I mean, I don't see how a text message. I mean,
Yeah.
when would you have got your phone? That Tuesday to look through it?
Mm-hmm.
He looked
He
through
was
it.
in the room. Mm-hmm.
He made you open it up for him. Yeah, but any conversation you have with this guy, he would have been like, "I live in the bricks," right? So shaking your head no. I mean,
Yeah, I don't know how.
he'd probably find out from asking around who you were seeing.
Yeah.
You know. All right.
And I know he has a habit of, like, he used to follow me, too, so I don't know.
He could have done
probably
that.
could've- Yeah.
He could have done that. That's it. We're gonna get out of your hair. I'm gonna turn this off. We're gonna leave. You still got my card, my number on it, or you probably got a bunch of cards, don't you?
I do.
Yeah. Yeah. Go turn this off. I'll give you my card and part your hair.
Next, we're going to listen to the police interview with Elisa Thompson's father, Eugene Thompson, who had been desperately searching for his daughter while she was missing.
You need to talk to Country.
His Country, who you call Cornelius?
Mm-hmm.
Yeah, we're going to have you call him in a minute. We want to get a couple things from you. So kind of start from the beginning for us of where you became aware of everything.
I came aware of it around 7 last night. I was headed out to a job. Mm-hmm. And the daycare called me. Said that they've been trying to contact my daughter and that my grandbaby is still here. Mm-hmm. I said, what? I said, did you contact the grandmama? She said she's been contacting everybody. And you just called me and I just picked up. So it was shock to me. So I drove back and parked the van up and jumped in my Mustang and just sped over there and got my granddaughter. Mm-hmm. And picked up my granddaughter and I asked her, well, where's the seat? Nobody had it. I said, okay, I'll strap in my Mustang and take her to the house. And I did that. And I called her mom, the grandmama. I called the grandmama, I called Lisa, couldn't get Lisa, nothing. So I finally got hold of the grandmama. And I said, look, I got Giselle, nobody picked her up. I picked her up just now. Now, I need to know what's going on. Then she came, and she had my grandson. And I started doing my investigation myself.
What did she tell you? How she got the grandson?
She got him from his dad.
Okay.
Because she called the dad, and he had picked him up from school.
Okay.
Around 5. And she went and got him, and then came with him. So at the same time, both kids together. And I was just trying to figure out now, well, where's my daughter? Mm-hmm. And sent my other daughter out to her job out on Mahan to find out if she's out there working still or what. Mm-hmm. Good. And she work at some call center, and it's very, protected, where you just can't walk in.
Right.
And nobody seen the car, so what I look at, I started doing my investigation. Mm-hmm. Then Jaden Daddy called me back. I was on Highway 20.
Who's Jaden's dad?
Antoine.
Okay.
And he called me back and said that the police supposed to meet him at Lisa's place, in a little bit. Mm-hmm. So, hey, I made his way out on Highway 20 because I do my radius, what I do in mobile repairs. Mm-hmm. So I said, wait, some tell me just go Highway 20. Instead of going, I usually go 90 towards the truck stop. I went the other way. Mm-hmm. So when he told me that, I turned around by Shady Grove Road, by the tire store, mm-hmm. and come back to town. And I came to the house and waited. So he called her to see how long she gonna be. She said she's en route, right?
Who?
The police.
Okay.
But she never came. She took all the information on the phone and all that. And I said, well, we want to know if I see the light on in the house, in the back. The door is kind of jog a little bit.
The house where?
The apartment.
Okay.
For my daughter. Because I have big spotlights. So I took one of them down and walked around the back.
Okay.
And try to shine in. And I could see the light plugged in the wall, the air freshener. Mm-hmm. But I wanted to know if she got a bag packed. I need to know something.
Right.
And what got me was she never came. She said she's soon going to be there and never did. And telling me all these scenarios of if she's on medication. I said, listen, my daughter is a college graduate. She got 2 kids. She never done nothing like this.
Was this dispatch?
Yes.
When you were calling dispatch? Okay.
Yeah.
All right.
So I said, this is wrong here. And you never showed up. And the more I think on it, I stayed out at night looking for my daughter, can't find her. And I went home probably about 3 o'clock.
Where were you looking for her at?
I'm looking for the truck. I searched every hotel in Tallahassee. I went all the way up on Appalachian Parkway, go all through the parking lots, just looking for the truck. If I ain't seen no physical body, but at least if I find the truck, I know where I'm going.
Right.
And
what made you go to Highway 20? Was it that you were going that way home?
No, I was going Highway 20 to go to the truck stop area and work my way back.
To start looking at the truck stop and come back. Okay.
But I never got that far.
Looking for her car.
Right.
Okay.
And then when they say they find the phone at a house on Highway 20, and I've been out there last night, you know, I'm right here in the area. I could have seen something. If I'd stayed out there, maybe a little bit longer, I might have seen the truck. Right. You know, and my thing is, after all that, I just kept wondering what's going on. I told the mom, okay, said the daycare want to hold the kids. Okay, let them hold the kids. And she went up and went to her job to find out what they could tell her. Mm-hmm. And she called me back and tell me what they said. And I said, well, we need to have a video of who this person is and who is standing outside and sped off. I said, that area out there have a lot of cameras that's out there on the I-10 into that big complex building. Right. So there's a lot of videos out there to see who out there. And whoever was standing out there, somebody had to drop him out there. Or whoever the person is. And you drove out my daughter's car. And you're not on the insurance, but you drove that car. And that's why I told you, detective, y'all need to do something. Don't let me catch that person. Because I'm different. I don't got time to wait for you guys to do your part. I will have the person. And I don't want to get to that point. Right. My mind is set. Because if it's country, I called him already. And I told him.
So when did you call him first?
I called him this morning.
And country is Cornelius.
You're right.
That's the one, she's the 1-year-old, the youngest one, is his kid.
Right.
And she has the injunction on him.
Right. Huh?
And they've had history in the past.
Right. So, in the past, when I found out that he had kicked the door and the knock out, and 2 kids in there, I hunt him down. My boys find him that works with me. They hold him up, and I got there. The other one that came, he don't play. He's my blood, and he's cousins. And he told him, he didn't spoke to him or nothing. I had to stop him because he was going to put him out right there in the parking lot. I said, no, I need to know what's going on. And I said, first of all, you kicked that door. You had no business touching it. You don't live there. I said, 2 kids in there, you putting trauma on them kids and my daughter. And if she don't want nothing to do with you, you're giving me a cited that she's bothering you. Well, she's bothering you, why are you doing over there?
Right.
So my thing is this. I told him right then, if I find out that you did anything to my daughter or anything at all, I ain't got nothing more to talk about because I'm done talking. And I told the mom that this month. I said, that's it. I'm silent, but when I get to that point, ain't no more talking.
Okay. So when did you start getting calls from country?
I called him this morning.
You called him this morning around 7 o'clock this morning?
No. I called him this morning. Let me show you. You got this information too, right? From the school?
Yeah, the other investigator has that one. So that's his number.
That's his number. That's the call I missed. So let me hit back.
Hold on. That's his number.
Yeah. That's him calling me.
That's him calling you. Hold on 1 second. Let me go give this to them.
No.
I just wanted to give them the phone number because we had it at different. I'll be right back in. Just hold on for me. All right. Sorry. I just wanted to make sure they had the right number because the stuff they were doing. Okay. We had it 1 digit off. So.
They did.
Well, we've had other numbers that he uses too. Okay, so that's the number you used. So this is
the time I called him.
Okay, so 2 hours ago.
Right, and he called me back.
Did you leave a voicemail or?
No, I spoke to him directly.
Okay,
so he called me back
1 hour ago.
Yeah,
okay.
While we're down at the school, but the detective told me wait till I get there to call him back.
Yes. Okay. So, all right, so let's talk about when you called him this morning. When you called him this morning.
And I called him this morning. I asked him, I said, have you heard what's going on with Lisa? Have you seen Lisa? Mm-hmm. He said, no, he haven't seen her. He said, everybody been calling him, asking him if he's seen Lisa and all. He said he haven't. And then he asked, do I need to come get Giselle? I said, you don't have to come get Giselle because Giselle is fine. I picked her up, and ain't nobody getting Giselle.
Did he say where he was?
He said he was in Tampa.
Okay.
right? Then, before I got off the phone, the last thing you told me that you can be here. So that got me more suspicious, like you still here, you're not in Tampa. Mm-hmm. You know, and I remember you answered me a question like that before. And it took a while for me to find you, but I found you because you were hiding. Mm-hmm. You wasn't at your house, but I found you.
Right.
You see, and I have other vehicles, so I jump in my Crown Vic, and that's how I found him.
All right. So what did he say this time this morning?
This morning, he was normal, like he never done nothing.
It didn't seem like he knew anything.
Right. And my thing is, when Judy told me, the mom, my wife, that they said a person was at the job in a hoodie and they sped off in the car, that made me think on him because he drive the truck crazy. Mm-hmm. You know, like he can drive fast and all that, and he has spent time with me driving in my Mustang, and he wants to drive. I said, no, you cannot handle this thing. And I told him then, I say, I love my kids, I love my grandkids, I love my family. You ever treat my daughter wrong in any shape or form, I'm going to take care of you myself, because I'm going to take you on the farm point blank, and I will deal with you. I said, I live life, and ain't nobody going to hurt them.
All right. Well,
so I'm calmed down. You know.
I know. Yeah. It's a stressful situation we're working on. We got the whole unit over there doing stuff on top of you.
And my thing is, so I kept it cool with him, just trying to see what's going on.
See if he knew anything. Did he seem like something was up with him or anything?
No, the only thing that triggered my mind is when he told me he can
come get the baby.
Yeah, like I told you already, you can't come get her. She's fine. I got her.
Okay.
And
so you haven't heard from him since then?
No, because they told me not to answer him.
Well,
so I wanted to call him, but he said you all have to hear it, and I will put it on speakerphone.
Yeah, that's what we're about to do.
And I would talk to him and see what's going on.
Yeah, but just talk to him calmly. Don't make any threats or anything like that, okay? Mm-hmm. So let's go ahead and do that and give him a call and just see what he says. And, you know, obviously ask him. He's probably going to know something. There's a reason why he's calling you back. Mm-hmm. See what he knows.
I would just let him know I'm working.
Yeah.
You know, to get my mind off of things.
Yeah, he doesn't need to know that you're here with us. Or
right. I won't never do that.
Okay. But don't make any threats, okay?
No, I won't.
All right. Yeah, go ahead.
All right. That's it? Yeah.
Hello?
Hey.
Yo, what's the update?
Nothing much. I've been working, trying to keep my mind off of things.
So y'all haven't heard from her?
No, I haven't heard. Have you heard anything yet?
Nah, it's just everybody calling me because they seen like some missing posters like on Instagram and stuff like, hey, is everything all right? But you know, I know just as much as y'all know. You feel me? Mm-hmm. So I heard you say something about her phone. Y'all found her phone?
I never found her phone. That's what I heard they said, but I don't know yet, and I haven't seen it yet.
Oh, but y'all traced it?
That's what we're doing. We're trying to trace it because it's dead. Yeah.
Oh, okay.
Trying to make sure that's her phone.
Did she call off from the job? Has the job heard from her?
I don't know yet. Because I sent her mom out there to find out.
Because if she called off from the job, then you know she's all right.
Yeah, I don't know. So I got to find out if she called in.
Yeah. All right, just let me know.
Okay. Where you at right now?
I'm at my house in Tampa.
Oh. Okay. I thought you were here.
No.
Okay. I'll call you and let you know what I found.
Oh. Okay. All right.
All right.
Okay. Is there anything else that happened between the time you found out? So you found out when you went and picked up the baby from daycare. Mm-hmm. And that was the youngest.
Yes.
And then when you called her mom had already had the other baby from...
No, my wife had the other baby.
Right, which is Lisa's mom.
Yes.
Lisa's mom. Okay,
yes,
sorry.
Yes.
So yeah, the baby's grandmother, but Lisa's mom.
Mm-hmm.
We'll be talking because Lisa's the subject here. So
right.
So I don't want to get confusing because there's so
Yeah,
many parties. So the baby she got from that baby's father. Was it Alton?
Alton, you're right.
Alton.
Yeah.
Okay. And then that's why she knew. So she knew that she hadn't picked up Jaleesa or
Giselle
or
Jaden.
Or Jaden.
Right.
Okay, so neither one of them have been picked
right.
up.
But see, he had him, which is his time to have him for Wednesday,
Mm-hmm.
and he take him to school Thursday.
Mm-hmm.
And Lisa took Giselle to the daycare.
Right, and hadn't picked her up.
Right, and I happened to pick her up because they called me.
Okay.
They said nobody else will pick up, and they've been calling.
Did Alton call you and tell you anything? Who told you about what happened at her job with the guy in the hoodie? How'd you find out about that?
My wife told me.
Your wife told you about it this morning. Okay,
Yeah.
so that wasn't last night. That was this morning.
Was this morning. Because
Okay.
she went out there this morning after dropping the kids them off.
So she went to the job site this morning, and that's
Right.
when she found out.
You know, and
Okay.
I told her to go out there to find out, and at first she was going, leaving the kids. I said no, because I ain't gonna be here. I gotta go to do something. I gotta find my daughter.
Okay.
And so then she said they want the babies. They want the school want to hold them to be out of the way so we could get to
Figure out what's going on.
Right.
Okay.
And at least we know they're safe
Right.
where they're at.
Absolutely.
And my thing is, I want to know what's going on and who all is involved.
Mm-hmm.
I just need to get to the bottom of it. And my thing is, if my daughter truck is out somewhere and who got her kidnapped or whatever the case may be, I just want my daughter back. You can
Right.
keep the truck. I give her one of mine.
Right.
But I want my daughter
Come back safe. Right.
You know, because if you damage or hurt that, my angel is hard. I'm a different person. You know, and I came a long way, and it's hard.
Right. I understand. All
So
right. Okay.
that's all I know. And like I keep telling them, I want to be. I also told them to go out on these roads, and a lot of your officers say they don't know them.
Probably because the counties are usually out there right now.
Yeah, the landings out there because I fix a lot of RVs.
Yeah. So what made you think to go out there? Was because you heard about the phone being found out there?
No, I was out there from last night.
I know you were out there from last night.
Right, but now that they found the phone,
so that's what alerted you to be out there.
To go further out to
Okay.
the different landings.
Okay.
And this is one of them here, right there, Williams Landing.
Williams Landing, Rough Lake Talcott. Here, I don't know what happened there. I tilted it.
Okay, Williams Landing. Battery low this way.
Yeah. Okay. Do you know of anybody that she was dating or talking to
No.
recently?
Mm-mm. That's where all that is Williams
Okay.
Landing. It takes you out to the lake.
All the way out to Lake Talcott. Okay.
Yeah. And this is the entrance right here.
Bluntstown and Patchwork.
Yeah. And then after that, we start seeing them on your right when you're going out.
Okay.
And then you'll see by Blossom Cutoff.
Mm-hmm.
Let me get it. Let me see here. Try to keep up with it here. This is another one up in there, up in
Okay.
that road. Yeah, that's what it'll do. It's like a loop around.
Yeah, I think I've driven
So
out there.
right at that corner, like a Y,
Mm-hmm.
straight across.
Straight across. Okay.
You see a big gravel pit opening,
Mm-hmm. I know what area you're talking about.
and you see the big towers, the big poles that carry the current,
Mm-hmm.
all up in there.
Okay.
You got RVs, you got RVs, park, camping grounds up in there.
Okay.
So that's another way that's where I was going.
That's where you're going. Okay.
Yeah.
All right. Give us just a second because I think they were working on something else right now. And we'll get you out of here. We'll pull her mom back. Okay. Thank you.
Finally, we're gonna have a hearing in this video from the wrongful death case where I represent Eugene Thompson as the plaintiff. Eugene Thompson is a personal representative of the estate of Elisa Thompson, and We have filed a lawsuit against two defendants, Elisa's employer, Conduent Business Services, and the landlord for where she worked, Hillside Building, LLC. The wrongful death case is about one simple fact. Conduent had noticed before Elisa was taken that one of their other employees, Shaterica, was being threatened and harassed, had been kidnapped and assaulted and terrorized and hurt by an ex, Mr. Gibson. Therefore, we argued that they should have known that Mr. Gibson, who was still looking for her to carry out his threats, might have gone to the property, and that's what he did. Eventually, he went to the property, could not find Shaterica, and instead grabbed Lisa. So that's what the lawsuit is about. And in the hearing that you're going to listen to, the judge is considering the defendant's motion where they're trying to get the lawsuit thrown out, saying that neither defendant had a duty to protect the employees of Conduent, including Elisa Thompson.
In the Circuit Court of the 2nd Judicial Circuit in and for Leon County, Florida, Eugene Thompson, as personal representative of the estate of Elisa Margaret Eugenie Thompson, plaintiff, versus Hillside Building, LLC, and Conduent Business Services, LLC, defendants. Hearing before Honorable Angela C. Dempsey, September 14, 2022, 1:30 p.m. Location, Zoom video conference reported by Deborah R. Crick. Appearances, representing the plaintiff, James P. Waksuski, representing defendant Hillside Cody Short, ESQ. Pennington, PA. For defendant Conduent James P. Hanratty, ESQ. Sean J. Reeves, ESQ. Proceedings.
Good afternoon. This is Judge Dempsey. We are here this afternoon on two motions for summary judgment in 20 CA 2192. Why don't the lawyers for the plaintiff put your appearances on the record?
James Waksuski for the plaintiff.
Okay. So just you for the plaintiff. And then how about for Hillside?
Your Honor, this is Cody Short on behalf of Hillside.
And then who is here for Conduent?
Afternoon, Jim Hanratty for Conduent. Sean Reeves is here too.
And, Judge, real quick. I had somebody who was supposed to come in and take notes for me, but she hasn't shown up. There may be somebody trying to come in.
Okay. There is no one in the waiting room currently.
Okay. And who is Edith Georgie?
Good morning, good afternoon, Your Honor. I am just an interested party. I've been following, not a party, been following the case. That's all.
Okay. Okay. So I, of course, have read both of the motions. I have read the plaintiff's response that was filed, I believe last week. I have read most of the depositions and other materials. The plaintiff dropped off some materials an hour or so ago, and I have read those somewhat quickly, but I have read those. So who wants to go first for the defendants?
Your Honor, I think that's me, Jim Hanratty.
Okay. Is that okay with you, Mr. Short?
Yes, Your Honor.
Okay. Sounds good. Okay. Go ahead, Mr. Hanratty.
Thank you, Your Honor. And thank you for letting us know how much work you've already put into this case. It may help streamline some of the arguments a little bit to know that you have an intimate knowledge of the facts as alleged by the parties. As the court is aware, this is a summary judgment hearing. The summary judgment rules changed a bit this year and now follow the federal rules. But that doesn't really change so much the issues in this case, in that the issues before the court, that of duty and control, are the same. Duty is a legal issue. Duty by defendants to the plaintiff is a legal issue according to the Florida Power and Light case which was cited in the materials. And then the other issue is that the general rule in Florida and elsewhere is that there is no duty to protect others from criminal acts of third parties unless there is an exception. And the only exception is if the defendants were put on notice of prior criminal acts or a pending criminal act, or were engaging in conduct that otherwise created the zone of risk. We will talk about what kind of Things create a zone of risk in a moment. But both of those issues of notice in zone of risk presuppose that the defendant, Conduent in this case for our purposes, controlled the area where the criminal act occurred. Your Honor, our argument is twofold and is a bit circular as well. First, we argue that there is no duty to the plaintiff's decedent in this case because there was no notice of any hazard of criminal acts on this property, and there was no conduct that would rise to the level of creating a zone of risk. The second part of the argument is that the incident with Ms. Thompson began in a parking lot, which was completed off-site. Conduent had no control of the parking lot pursuant to the lease that they had with Hillside. There was no access control. They did not have any control of the parking lot and no involvement with the parking lot other than allowing their employees to park there and come in and come out and use their cars for breaks or sit on benches outside. But according to the lease, there is no control of the parking lot, and that's consistent with the case law as well. So first, Judge, plaintiff makes a lot of allegations in the complaint, but those allegations are almost uniformly refuted by the record evidence, the summary judgment evidence before you. The fact is that there were not only is there no evidence of prior violent acts on this property like you sometimes see in negligent security cases, so not only is there no evidence before you of any violent acts, there are none. There is no history of violence on this property such that a landowner or controller would have been put on notice of a propensity or for violence to occur on the property. So throw that notion out, that's constructive notice element is just not existent because it's not supported by the record evidence. Essentially, the plaintiff's entire argument on notice is based upon a woman named Shaterika Dawkins, who was a young woman who was also an employee of Conduent, but she worked at home. She didn't work, at least for the month preceding the events we are talking about. She worked at home. She did not work on site. She had an incident a week or so, several days before the subject incident in this case, whereby Mr. Gibson, the individual who's accused of injuring Ms. Thompson, I believe he hasn't been tried or convicted yet, and she had a prior relationship, and Mr. Gibson, at some point, met Ms. Dawkins at a different property, miles away from this property, and according to her, kidnapped her, assaulted her and injured her but all of that happened at a daycare where her son went to school or went to daycare. Ms. Dawkins claims that she reported that she needed to miss a couple of days of work because she had to, or at least one day of work, because she had to report this incident to the police, and then, in fact, she had reported that incident to the police. But what she reported was that there was an incident that happened miles away from the subject property that involved her and involved no one else and did not involve any threats to anyone other than her. There was no evidence, in fact, and there is no evidence before you of Mr. Gibson posing a threat or notice of Mr. Gibson posing a threat to anyone other than Ms. Dawkins. And she did not report any threat of any conduct on the subject property. In fact, we know this not only by her words, but by her actions. Even after her attack by Mr. Gibson, Ms. Dawkins testified that she no longer felt safe at home because he knew where she lived and he knew that her son was with her, but she did feel safe at work. In fact, she felt when she went home to get clothing and other supplies so she could stay somewhere else, she had a police escort her, but she never had the police escort her to the subject premises. The plaintiff claims that she was, in fact, and Ms. Dawkins indicated that she felt in deposition testimony that she felt safe at work. In fact, she wanted to return to work because she felt safer there than she did in her home. Plaintiff claims that Ms. Dawkins put Conduent on notice of some risk of harm despite the fact that even she didn't see any risk of harm at this property. To the contrary, she thought that this was a safer property for her, and that's why she wanted to go there to complete her employment duties. So the court is being asked by plaintiff to make an assumption based upon a lot of conjecture. That somehow Ms. Dawkins was able to put Conduent on notice of a risk of harm that even she did not appreciate. How is it that she could conclude that Conduent could be put on notice by someone who doesn't even comprehend that notice? Even she said, even when confronted with additional information on the 30th, that Friday of that week, when she reported to work without police escort. She saw that the police were there. She heard some discussions with other employees regarding the fact that Ms. Thompson was missing. And even when she heard that additional information, she did not make the connection that Ms. Gibson had anything to do with Ms. Thompson's disappearance. So once again, plaintiff is asking this court to conclude that notice was provided to Conduent by someone who had not even made any connection that would create that notice. It is not supported by the record evidence. It's not supported by common sense. It's not supported by the only witness that they feel supports them. So there is no evidence of this constructive notice. There is insufficient evidence of an actual notice because it never existed in anyone's mind before the act. The next issue is the zone of risk. The cases that address the zone of risk all talk about something, some different event, some different conduct that creates a zone of risk. One of the cases involves there was a party involving alcohol, and so that created a zone of risk. But the court was careful to kind of differentiate that holding from the federated case and the public's case, which we have cited in our materials. The public's case in particular was one where it involved a parking lot. And in the parking lot, in this case, there was a Good Samaritan that was shot by a purse snatcher. The court ruled that there was no control over the parking lot, which is another basis of our argument, but also that there were no actions which created the zone of risk even though the parking lot was being used by publics. So there is no record evidence of any of this zone of risk being created simply by operating a business and using a parking lot. There is simply none of the conduct rises to that level. So then we move to the control issue, and the issue is that the record evidence before the court indicates that the lease signed by Conduent confirmed that Conduent was not in charge of, or that the common area, the parking lot, was not part of the leased properties. The lease specifically included the parking lot, as it does here. And in the public's case I just referenced, that lease also excluded the parking lot. The legal duty to protect invitees from injuries caused by third parties is not just tied to the notice issue, but it's also tied to defendants' control over the premises where the injury occurred. That was as stated in the Competitive Softball Promotions vs. AUP case, which was cited in the materials. In the competitive softball case, there was a fight in a parking lot that was being used by the defendants for parking cars and collecting money. The court ruled that was not sufficient control of the parking lot to make the defendants responsible for a fight that occurred. Same deal with the Publix vs. Jeffrey case, the Good Samaritan case where he was running down a purse snatcher and got shot for his heroism. The court also ruled that there was not enough control for Publix of the parking lot, even though their customers parked there, their employees parked there and carts were stored there, very similar to what we have here, employees and customers using the park lot. That's not enough control, especially when the lease excludes it. So our motion, as I said, is based in two parts: no notice, no zone of risk, and no control. Plaintiff responds to this fairly straightforward argument by a collection of citations to deposition testimony without really addressing the issues before the court. The brief does not address, at least the one previously filed, does not address the lack of criminal acts. The brief that was filed at 2:43 this morning, I appreciate that the court has reviewed it, but I also would object to any references in the record to that simply because it's filed well out of rule, despite the fact that extensions were given to plaintiff's counsel. So I just wanted to make sure that objection was on the record before we go any further on that. But their response does not address the lack of control of the parking lot. Instead, plaintiff's response invites the court to listen to his storytelling of an event with no evidentiary basis for the tale that he tells. There are multiple references to individual states of mind, including Mr. Gibson, Ms. Dawkins, Ms. Thompson, and Ms. Bornereau. He claims in his argument that and I am quoting here, the predictable happened. And here's what he said was predictable, that Mr. Gibson knew there was an arrest warrant out for him. He knew that he was probably going to spend the rest of his life in prison unless he committed suicide by cop. And so he decided to take Ms. Thompson, kill her, use her phone and vehicle while he searched for Ms. Dawkins. The claim of this demonstrates against better than most of the other arguments in this case, the thin line of plaintiff's arguments. And that simply is he is asking the court, the estate is asking the court to determine that this recitation knew there was an arrest warrant out, suicide by cop, going to take Ms. Thompson, kill her, use her phone, all of that is predictable based upon Ms. Dawkins saying she had received some harassing phone calls. She had been kidnapped by the father of her child, and sexually assaulted miles away from this property. The link between Ms. Dawkins telling her employer that the father of her child and she were engaged in this domestic issue, the notion that that is predictable, and the notion that it cascades this other series of facts is fantasy. There is no evidence of what Mr. Gibson's state of mind was. No evidence that he knew what he was going to do and he had a plan. And there is no evidence that involved Ms. Thompson at all. This was a sudden, unforeseeable, unpredictable act by a criminal that Conduent had no control over him and had no control over the property. Mr. or plaintiff's, I am sorry, response goes into a long description of what happened with Ms. Dawkins and Mr. Gibson, but what does that have to do with this case? What does that have to do with the issues in this case? The description that is provided in the brief, even if it's all true, which is not supported, it's not supported by any record evidence, but even if it's all true, that doesn't have anything to do with what notice was given to Conduent, or to Hillside, for that matter, because that's not what she told. The detail in the brief, plaintiff's brief, is nowhere near as limited as what Ms. Dawkins said. Or I should say it better, Ms. Dawkins didn't give anywhere near the detail that plaintiff's counsel does in their brief. It relies upon this fantasy being predictable. It relies upon Ms. Dawkins having made some connection between Gibson and Thompson, which I discussed earlier. And it also references to something that Ms. Borner knew that was going on. It talks about her state of mind. It references something that Ms. Dawkins knew that Ms. Borner knew what was going on. There is no record evidence that Ms. Borner knew what was going on. In fact, nobody knew what was going on, and there is no record evidence of that before the court. The plaintiff's entire case, Your Honor, is built upon the notion that a domestic violence incident, which occurred off the property and off hours, put Conduent on notice of a potential risk to Ms. Thompson. There is no summary judgment evidence that demonstrates that notice or any acts that create a zone of risk. Your Honor, I think the first thing that plaintiff will stumble over in this case is one of the first things that they said in their brief. They say, and I will quote here, defendants cannot establish that the threat by Gibson was unforeseeable, close quote. It's not our job to prove a negative. It is the plaintiff's job to prove their case, to provide evidence to this court that establishes notice for zone of risk. They have utterly failed to do so by their loose collection of references to deposition testimony, irrelevant references to the details of the Dawkins incident. And their attempts to link this incident to school shootings and domestic violence has nothing to do with the case like this. The plaintiff does quote some case law, well, I take that back, refers to the cases. There is no case law analysis in the brief. But the cases that were relied upon, at least initially, include the Sherwood versus Quietwater case. That's the Bushwhacker Festival case where there was a party to celebrate an alcoholic beverage where the court ruled that the defendants created a zone of risk in a parking lot because of A, a temporary lease, and B, the fact that they were throwing alcohol into the mix. Neither of those factors are in this case. Plaintiffs reference the Hardy versus Pier 99 case. And Pier 99 was a motor inn that was next to a bar. The plaintiff showed evidence of prior acts of violence in the area. We don't have that here. They used calls for service. We don't have that here. And the court held that because there was a bar involved, and because there was evidence of prior acts, there was at least an issue of fact as to whether the defendant was on notice. The only act the plaintiff claims puts us on notice happened at a completely different place. Finally, they attach or they reference Satchwell versus La Quinta, which is a single violent act with no history of prior crimes. That actually supports our motion. The court held that because there was a single violent act, that the defendant was not held responsible for that attack because there was no evidence to support the notice issue. Just like there is no evidence here to indicate that Conduent should have known of this, foresaw this tragedy. Judge, in conclusion, it's our position that the summary judgment provides no evidence of the summary judgment evidence provides no actual evidence of notice, either actual or constructive. There is no conduct that Conduent was engaged in that created a zone of risk. And then so the only supported conclusion is that there, as the case law establishes, there is no duty by Conduent to prevent the criminal acts of others. The plaintiffs just don't have the evidence sufficient to establish the exception to that general rule in Florida. So we request that the court grant summary judgment in favor of Conduent.
Okay. Thank you. Mr. Short.
Yes, Your Honor. I appreciate Mr. Hanratty's in-depth analysis into all of these issues. I am going to do my best not to repeat, especially given the fact that you have taken the time to review everything ahead of the hearing. So the mass majority of what Mr. Hanratty stated in regards to Conduent is true for Hillside as well. Only that I think the distinction is that you have to go even one step further to get to a colorable claim against Hillside. It's fairly well supported at this point through the record evidence that we cited in our motion, that Conduent has cited in their motion, that no one from Conduent knew or appreciated any risk to any of its employees at the site on the premises at 1625 Summit Lake Drive. And that's important, because in order for the plaintiff to get to any liability on the part of Hillside, the property owner, it first has to show that somehow Conduent knew and that it also should have known, that Hillside also knew or should have known of a threat to someone on its premises. And the record evidence is very, very clear through the affidavit that we supplied and through the testimony of Conduent employees, that not only did Conduent not have any knowledge of it, they certainly didn't put anyone from Hillside on notice of any threat to Miss Dawkins whatsoever, of any threat to any of the employees on the premises, or any threat to the premises at all. And so Hillside found out about this whole issue on the news, after it was reported that Miss Thompson had been kidnapped. And so this was not a case where a tenant learns of something and makes the landlord aware of that threat. There is a significant question as to whether or not the tenant even knew. There is absolutely no question, it's completely undisputed that the landlord had no knowledge of any issue with Mr. Gibson and Miss Dawkins prior to the kidnapping of Miss Thompson. As Mr. Hanratty stated, 1625 Summit Lake Drive is part of a business complex located in a remote area with no history of any crime. It is primarily businesses. There is government contractors. I believe there is a FedEx facility out there as well. There is no history of crime on this property that would put anyone on notice of the need for security, or danger to the employees or personnel out there at the premises. And so from a notice standpoint, it is undisputed, and it is fairly clear, that Hillside certainly had no reason to provide additional security, or any security based on prior actions or prior violent crimes. It had no knowledge of any of the issues going on with Miss Dawkins and Mr. Gibson. And it certainly had no zone of risk issues, because as Mr. Hanratty pointed out, there is none of the factors cited in the case law, alcohol, parties, dangerous business activities, none of that is present at this business complex. And it is any argument that there is a zone of risk falls flat because of those factors. In support of our position on this, we cited deposition testimony from John Wars from Tel Aviv Borna Row, from Craig James, from Miss Thompson's parents, from Marcus Moore, several employees at Conduent, and everybody says no knowledge of threat to Miss Thompson or Miss Dawkins prior to the kidnapping of Miss Thompson. So the notice issue alone, we believe, carries the day for Hillside. It had no reason, no knowledge or, no constructive or actual knowledge or notice of any issue at the property. Plaintiff is certain to argue, as he has previously, or as counsel has previously, that Hillside somehow failed to have a system in place to allow for its tenants to make complaints of safety-related issues at the property. First, there is no known case law precedent out there that establishes that a landlord has a duty to set up any type of system for reporting of incidents. That is a fabrication for the purpose of this case by the plaintiff. I have supported record, or have provided record evidence in this case in the form of an affidavit, and also in the form of deposition testimony from Tel Aviv-born Rowe, who is the manager at Conduent, that the property manager at Hillside, Dolores Cawthron is her name. There is an open line of communication between Miss Cawthron and all of the tenants at the property, including Conduent and Miss Rowe. Miss Rowe testifies, as is cited in our motion, that she had an open line of communication with Miss Cawthron, that she had provided notice of issues at the property, not the safety-related issues, but other issues, directly to Miss Cawthron, and that if she had any issue, she knew that she could go directly to Miss Cawthron and report a problem. And as has been established here today, and through the filings, there is no such report. Not once did anybody from Conduent go to Hillside and say, "We have an issue here," or "We are concerned about an issue we are having with an employee." It's not present. I think the last bit of this argument, and again, I am trying not to duplicate arguments, is the control piece. The lease, as we cited in our motion, cites very plainly that Hillside does not provide security on the premises. It does not supply security guards. There is an argument made by plaintiffs that somehow there is either a joint control, or control by Hillside specifically of this area. That control issue is really not even, at least in my mind, should not be the focus of this hearing, because the notice problem that plaintiffs have is something they can't really overcome. You know, Mr. Hanratty, I thought pointed out very astutely that there are significant logical jumps that plaintiff is asking the court to make. And there is certainly present in the first response, as quoted by Mr. Hanratty, but I had another quote pulled from the brief, again, that was filed at 2:43 this morning. And I would like to echo Mr. Hanratty's objection on that issue. There has been plenty of opportunity for plaintiff's counsel to respond to the motions. Extensions were granted in order to avoid any additional delay of this hearing. And filing at 2:43 this morning did not allow for any substantive response by the defendants. But I am reading from page 2 of the memorandum of law filed this morning. And plaintiff's counsel is talking about the fact that Shatrika Dawkins made Miss Borna Rowe aware of the prior issue that she had with Mr. Gibson, and she's talking about responsibility to determine risk to its employees. And he says here that it's Conduent's responsibility, not Miss Dawkins' responsibility, and it was not a difficult task. Based on the information Miss Dawkins provided, it was totally logical to conclude that Mr. Gibson might look for her at her place of employment, that he committed a serious, almost deranged criminal act against Miss Dawkins, and he might be looking for her to finish the job, or to kidnap her again. Then the next logical step is that a desperate and dangerous man like Gibson might commit criminal acts once on the Conduent property to gain access into the building, or to gain control of someone to help him enter the building if he had found Miss Dawkins' vehicle there, or that he might do something else to a co-worker in an effort to use the co-worker, or her phone or her vehicle, or both to facilitate finding Miss Dawkins. There is also the logical conclusion that if Mr. Gibson kidnapped a young lady just 2 days before, he might do that again to another lady while he was at Miss Dawkins' place of employment looking for Miss Dawkins. This is further evidence of the number of logical jumps that have to be made in order for plaintiff to establish a case against either Hillside or Conduent. These are, Mr. Wachowski has categorized these, or characterized these as logical conclusions. I would submit to the court that these are logical jumps that are only supported by hindsight. We only know that these facts could be possible because of the fact that we now are able to see what happened. We've seen this play out. There is absolutely no way that anyone at Hillside or Conduent could have foreseen this, as Mr. Wachowski calls it, a deranged act by Mr. Gibson. And it's very, very clear also in the record evidence. We took the deposition of Detective Nick Roberts from, I believe he is with the Tallahassee Police Department. And Detective Roberts is part of the homicide unit at TPD, and he is asked the question point blank, would you call this a random act of violence? And he says, yes, I would categorize this as a random act of violence. He is a homicide detective. He does this for a living. He does this day in and day out. If there is somebody more familiar with what a random act of violence is, I would like to see them. And that is what we have here. It is an absolutely unforeseeable random act of violence for which Conduent and Hillside have no liability, have no ability to protect their tenants or their employees from, and no duty certainly to do that either. And for those reasons, we believe that summary judgment is appropriate in this case as to all the claims against Hillside, and we would ask the court to enter an order reflecting same. Thank you.
Okay. Thank you. Mr. Waksevsky.
Hello, Judge. Nice to see you. First of all, I would like to address the issue of the memo that was filed in the early morning hours, as there was an objection raised, and I want to just lay out a couple of things. The rule of civil procedure that has been amended, and I thank everybody for giving me the extension to file a response, requires a response in the sense that the movement has pointed out to some record evidence that supports summary judgment, and the rule requires a response so that if I want to point out to the court, here are some other portions of the record that oppose the fact that summary judgment should be entered, that create a material issue of fact in the case, then I have to do that response and I have to include those. And that's what we did. The response that was filed last night is simply something to assist you today at the hearing. I could have just made orally the same arguments that I make in that response last night, I could have made them today. And simply I had given notice to the parties that I would be doing some additional research. There was a lot of stuff that was argued by both sides, and I was preparing for this hearing today, so if I found additional cases, I would submit them for everybody to review before the hearing. And I did that, so those are attached to the memorandum that I filed. There is no reference to any new record that has not been before the court in the plaintiff's motion for summary judgment or in my response. The only references I make to the record are to things that I already covered in the memorandum that I filed, and to things that the defendants, themselves, when they moved for summary judgment. For example, they pointed out several lease provisions. So I addressed language in the lease that was an attachment to the motion for summary judgment, so there is nothing new there, nothing that should be objectionable. I am simply, somewhat helping make it easier for everybody to understand what I am going to be arguing today. So with respect to the specific responses, obviously there is a lot of things that were said by both sides. I am going to start with Conduent's motion. But generally speaking, Judge, let's just make one thing clear, right? We are here on a motion for summary judgment. Both sides are arguing there was no duty. 25 The issue of duty is for the court. There is no doubt about that. And the issue of duty is simply for the court to determine whether the courthouse door should be open to the plaintiff, not determine whether people should be liable to the estate of Elisa Thompson. That's not your job. Today. You are not determining today whether anybody breached the duty, or what was the scope. What do they have to do in response to domestic violence in general, and or with respect to the notice they received from Ms. Dawkins, that Conduent received from Ms. Dawkins. You are not determining that today. What you are determining is whether the evidence presented, and the relationship between the parties, because we know that Conduent was the employer. Elisa Thompson was the employee. And it just happens she was kidnapped within the premises of her employment. She was parked for her job. She was there on a lunch break where there is very short lunch break. She could have been there on a break on the clock. I mean, it's just employees are there all the time for breaks, to go get their cell phones during breaks, to go smoke. There is designated smoking area. And lunch breaks are very short, and the testimony has been that this parking lot is used, especially was used by Elisa Thompson often as a place where she would have lunch because of the very short nature of the lunch break. So summary judgment, Your Honor, all of the evidence that has been presented has to be seen, and the reasonable inferences they are from, have to be seen in the light most favorable to the non-movement. And we are here, we are non-moving parties. We are opposing summary judgment. So all of the evidence, and reasonable inferences from the evidence have to be looked in our favor. Neither defendant has done that in this case. They have presented to you the facts and the evidence tilted completely the other way, so why they believe that they should have no liability in this case. One short example before we go into all the details is the testimony of Detective Roberts. I cross-examined Mr. Roberts after he was receiving a lot of questions that obviously they were trying to get sound bites perhaps to use for summary judgment. And one of the issues was, for example, there were 2 witnesses who saw what happened to Elisa Thompson and did not call 911. Did not realize what was happening. And when Mr. Roberts testified and he was being asked questions by the defense attorneys, they tried again to say, yes, this was a random act of violence, and so on and so forth. But then when you go to the cross-examination, we address the issue in great detail. And what we can determine is this: what he was talking about is the fact that he has seen no evidence whatsoever that Elisa Thompson had a prior relationship with Reginald Gibson, where maybe he was targeting her specifically. That's what he meant, that this was a random act, that this was not a targeted attack to Elisa, that he hadn't seen. Oh, here's my ex-girlfriend. Let me go ahead and kidnap her, rape her and kill her because I am also angry with her. That's what he meant. The same thing when he was describing the testimony of the 2 people that saw this event, he actually said that both of them told him that this man was suspicious. And then later he gave, in responding to questions from defense counsel, he gave his interpretation. Well, I believe those witnesses probably were thinking, in hindsight, after the fact, knowing that she had been kidnapped made him look suspicious. But, that's, again, an inference that they are asking you to make without taking the testimony or the deposition of those 2 witnesses. And they are asking you to rely on an interpretation from the detective about what might have been in the minds of those 2 witnesses. So what the witness says, including Marcus Moore, who was a co-employee of Elisa Thompson and who actually was dating her at the time, that he had seen a person that was suspicious in the area. We also all know that nobody was told by Conduent that there might be someone coming after one of their co-workers, Ms. Dawkins. But anyway, I jumped a little bit ahead of time on my argument. I am going to go back now, and with the proper understanding of what summary judgment is about, I would like to respond to some of the arguments made by Conduent and by Hillside. Now, Judge, obviously I have done a written response, and I appreciate it very much that you have had a chance to review everything that I filed, and I understand that you read the memorandum that I filed last night in a rush, and I am hoping to go over that as well in the hearing. I really just was trying to facilitate the argument today. But on the question of Conduent, and the question is here whether or not Conduent, who was the employer of Ms. Elisa Thompson, whether they had a duty. That's the only question for the court today. And obviously, Judge, as the employer, they automatically have a duty to protect their employee, Elisa Thompson. They had a duty to ensure that she has a safe work environment. And that usually does cover the areas around work. She was in the parking lot for the job. So there is a duty automatically from the special relationship. And I attached for you, Judge, several cases that talk about the special relationship. And I also wanted to point out several of the cases that the defendant relies upon don't have that special relationship as a factor, and that's why they are substantially distinguishable. So here, we have an employee. This attack could have happened inside the building. This attack could have happened outside while she was on a break. It happened while she was at lunch. That's really not what the specific facts of what happened are helpful for the analysis of the case. But the question really is whether there is a duty to make sure that that the employees have a reasonably safe place to work. And so the next question is, if you receive actual notice of an incident of domestic violence, or personal violence, can the employer just put their head in a hole and just say, don't ask, the policy is don't ask, don't tell. We don't want to know about your crazy boyfriends, your crazy exes. We don't want to know if somebody has threatened your life. We are just not going to care. We are a large multinational corporation, because that's what Conduent is. They are a federal contractor that does work for the Department of Labor, has a huge suite, huge call center space that they rent from Hillside, but they don't want to know. They really have no interest whatsoever on a specific threat. That's one of the issues here today, Judge. So if you look at the evidence in the light most favorable to the plaintiff, the evidence is clear. Shaterica Dawkins clearly and unequivocally testified in deposition. I attached the pages for you to read, Judge, that she did give notice to Conduent to Ms. Bonner Rowe, before Elisa Thompson was kidnapped, that she, herself, Ms. Dawkins was having huge problems with her ex, that she was kidnapped, that she was terrified, that she was injured, that she could not work, that she was afraid, that she was going to be making changes about her place of employment. And, Judge, Mr. Hanratty says that there is a lot of inaccuracies in the complaint. I am sure that you had a chance to take a look at the complaint. Obviously, this is a not of simple complaint. This is a very complex, detailed complaint, and there is one mistake, but there is only one mistake in that complaint that I acknowledged in the response, which is we had spoken to Ms. Shaterica Dawkins prior to filing the lawsuit, and we misunderstood. We thought that she had requested to work at home in response to the incident. But what happened was that just a few days earlier, she had started working from home, and the opposite happened. She had to make a decision, right? So she had been kidnapped. She was scared. This man was after her, and she knew it. She went and filed a domestic violence injunction petition. She obtained an order. And, Judge, I know that you have done that many times, and that you, yourself, Judge, have seen cases where a domestic violence injunction ends up in murder. The Sandra Frash case is one easy example that we all think about. I was representing her in the civil case from that one. And so, obviously, we have Ms. Dawkins that is extremely afraid. She notifies her employer. And then given her limited choices, Judge, because as you know, in a case of domestic violence, the terror that the ex-spouse, or the estranged husband, or the estranged boyfriend, part of that terror that they try to impose on their victim is they try to affect their ability to work, to earn a living. They want to keep those victims dependent on them, and they want to harm them. So obviously, Ms. Dawkins had to work. She had to survive. She had to support the child, who was also a victim. The child was also kidnapped. So what she did was make arrangements with Conduent, that given all of her choices, all of her options, she thought, well, I need to survive. I need to work. So of all the choices, I probably better be at the employer place. I can maybe get somebody to come out and look for me. And, remember, she would go there knowing who Mr. Gibson is. Knowing of the threat. Ready to react in response. She knew. She had the information that she knew that could make her going to work a little bit safer than anybody else that didn't know anything. So, Judge, the evidence is clear and unequivocally for the purpose of this motion that Conduent had notice of a very, very severe incident involving a female employee and an ex. The question is, Your Honor, do you just turn a blind side, do you just look away and don't care and don't do anything about it? Or do you listen to this and think, well, is there a potential danger from this, and is there something that we have to do? Because an employer has a duty to all of its employees, right? Maybe the corporate of this multiple I have national is somewhere else, not in Tallahassee, but the managers at the Tallahassee branch, they have to care for their employees, and they have to think, okay, well, there is a guy who did something horrible to one of our employees. Our employee is scared. Our employee, she should have asked the questions, okay. She should have asked more questions. She should have brought this up to security. And if security, apparently there is no security at all in the Tallahassee branch. If there is corporate involved, and she says, well, listen, I am going to try to get all the details, you need to speak to corporate in the Atlanta, or wherever their main corporate office is, but they should have done something. There is employers everywhere nowadays that have policies exactly like that. For some time, while handling this case, I actually had to leave my law firm and I worked for the state of Florida as a senior attorney for the Office of Financial Regulation. And I went through all their policies, and one of the policies there is exactly something about this whole issue, about domestic violence coming to the workplace, about what to do, and there is models, Judge. Nowadays, there is models. This was, I think, back in 2016 or 15 that the law school at Cornell, one of our Ivy Leagues, created a model policy for employers, and I attached that, by the way, to one of the filings and I did what's weak, a model policy to help employers navigate this very serious issue that maybe for a long time everybody just wanted to look away from it, wanted to ignore. But having significant cases, Judge, of situations where domestic violence, spread into the workplace and resulted in death on multiple people, I actually, in the response, cited to a case, I believe it's from North Carolina. I don't remember if I put that on the supplemental memo or the written response, but there is a case where one employee was looking for exactly a situation like this. The wife was sick and tired of the husband. So she tells him, okay, we are done. The guy didn't take it well, started making threats to her, and she went into hiding, but then she had to go to work. And then when she went to work, eventually he went there and he started shooting people in the parking lot. Then he went into the building and started shooting people everywhere, and the target survived because she had just been transferred that morning to a different unit within this hospice, or it was an elderly place, I don't remember what exactly it was, some kind of a hospital for the elderly, or home for the elderly. So she had been transferred to a division that had locked secure doors, so she was able to hide there in the bathroom. She was never killed. But then there was, I think over, almost 10 people killed, many more injured, in an incident because someone in this type of situation, a person was mad about somebody dumping them, decided to take it upon the employer, and tried to go find this person and kill them. When I mention school shootings, that's what I am talking about. This is not something new in the world. It's not new in Tallahassee. It's not new in the United States. Domestic violence, and the violence that comes from it is a real threat. The fact that sometimes it goes through the place of employment is expected because the perpetrators of this violence, they are after the victim, and the victim usually tries to go into hiding, and they may go to a special home for victims of domestic violence that most communities have that. Thankfully, but what is one place that they usually cannot avoid going to if they want to survive financially? That's their place of employment. So how is that a logical jump, an unexpected occurrence that someone who is dangerous, who committed a severe crime, who is likely going to be serving the rest of their life in prison, that person may go to the place of employment of their real target looking for them, and might harm them? So they might have gone there and harmed Shaterica Dawkins. They might have, like I said, I am giving possibilities. I am not saying, obviously, from the notice that Conduent received from Shaterica, they should have exactly guessed that Mr. Gibson would have gone to the property, kidnapped another girl, raped her, murdered her, taken her car and used her phone to try to reach. I am not saying that, Judge. Obviously, that's what happened here. But what I am saying is that the risk of the situation should have been assessed. Now, I never even addressed, never even alleged as to Hillside, for example, that they had notice. It's not even alleged in the complaint. What we say is that they should have known, right? And I am jumping a little bit back and forth. But let's talk about the issue of Conduent, Hillside, and the lease. What I included for you, Judge, to review in the supplemental memorandum that I did last night was some case law and provisions of the lease that show that the court, even though the cases are the cases cited by the defendant, and that case is Combs versus Aetna Insurance Company. That's number 14 on the table of contents that Conduent filed is 410 So.2d 1377. It's a 4th DCA 1982 case. That case requires, Judge, for you to deny the motion for summary judgment on the basis of the lease provisions, because it actually sounds almost identical to lease provisions in the lease in that case as we have here. And what the court says there is that Federated, which is one of the cases that Conduent is relying upon, both sides, I guess, are relying upon, actually are a different result. So the trial judge had made a mistake. Federated, this is, well, whatever the lease says controls, but misunderstood what Federated says, because there is an exception to that general rule. So if the landlord keeps control of the common areas, it has to be exclusive. So if there are lease provisions that suggest otherwise, then the court is required to deny that, and simply find that there is concurrent duty, by both the landlord and lessee, towards that common area. So here, we have several provisions of the lease that are almost identical to the ones discussed in the case of Combs versus Aetna Insurance Company. I cited that for you, Judge, in the supplemental memorandum. I described to you the lease provisions. This is on it starts on page 9, actually the case is Diaz versus Southeast Bank, okay. So Diaz versus Southeast Bank is the actual case. I am sorry. I told you the wrong one. And Diaz is actually number 17 on the table of contents that Conduent filed. So Diaz has, the lease in Diaz is similar provisions as to those filed in the lease between Hillside and Conduent. And with only those 3 provisions, like I said, this lease actually has many more, but only those 3 provisions are very, very similar. The court said, well, no, the opposite result is required, summary judgment should have been denied. This is a concurrent duty situation. But the lease provisions in this case, and even the ones that they cited to you in their motion, Judge. They cited to you paragraph 7 of the lease, but then they only quote the first half of it, and completely ignore the second half. There was literally an entirely different result. We can go over the lease together real quick. If you look at the lease, Judge, that they filed as an Exhibit A, and you look at paragraph 7, where it says maintenance by the landlord, they quoted to you just the first half, where it talks about how the landlord agrees to keep in good repair and condition the foundations, the natural structures. And I think it mentions there the sidewalks, driveways and landscaping. But then they failed to tell you the rest of the paragraph, which is super important. Except, it says, except, however, for any damage or injury caused by or resulting from any negligent act of the tenant. And or any of the tenants, agents, servants of the lease, licensees, invitees, customers. Which obviously the next implication from that is, Judge, well, if the landlord is not going to fix that, then who's going to fix it? What they are saying here, and I think the way that the court has to interpret it, that on a motion for summary judgment, is okay, well, I see that the tenant also has obligations if they cause any damage to the parking lot, or whatever, then they have to fix it. What about the actual facts in the case, actual facts of control? Judge, in this particular incident, who was it that hired security to patrol the parking lot right after Elisa Thompson was kidnapped? It was not Hillside. It was Conduent. In fact, Hillside, in its responses to discovery, multi-responses to interrogatories, I think it's in the response to request to produce, and all of this was filed last week. For example, in response to request to produce, we asked them for all, let me see, I think it's this one, numbers 10 request to produce. The request was all documentation in any way relating to notices given by tenants, tenant employees, or guests to Hillside regarding any safety issues, including actual suspected criminal activity on the property and/or the plaza. And the answer is none. They never had any communications. They don't have any communications. Why? It's very simple, Judge. Hillside wants to have the cake and eat it too. They argue, and Conduent argue, that the common areas are the responsibility of the landlord. But then when you look at the lease and the landlord disclaims the fact that it will do certain things that may be required, right? So for example, the lease specifically says we are not providing you security guards. So why would anybody from Conduent contact Hillside on a situation where maybe a security guard would be useful? The facts show you the opposite. The facts show you that, hey, there is a deranged guy on the loose. He might come back again looking for Ms. Dawkins again, and may do harm to somebody else. Let's hire security guards. Who does that? Conduent. That is control of the parking lot, Judge. And that is not the only evidence of control. When we asked questions of Mr. Lewis Ward, who is their security guy, who is not really a security guy. He is a guy with a bachelor's in business, and who is an IT guy. So really, he looks at the contracts, the Department of Labor and all the federal contracts. His job is to just make sure that they are complying with whatever minimum requirements are in the federal contracts. So he says they had incidents at Conduent that gave him concern. Incidents, for example, involving an employee who became disgruntled, upset, whatever, who had to be escorted out, taken to the parking lot. Escorted off of the premises. By who? Nobody called Hillside. Hillside already says we are not providing any security other than the minimum security that we already have in place, which is keycards to access the building at night, or key fobs, whatever, the electronic access like after regular business hours. That's it. There is no cameras outside. Nothing. They even say in the lease, we are not going to have emergency call centers, where people who feels threatened they can just pick up the phone and somebody can come to the help. At the same time, they are saying, Hillside is responsible for security, but Hillside says, we are not doing anything about security. We are not. Even in the responses to interrogatories, they said, we never did a formal assessment of security needs. They just informally look around and say, hey, we look for safety issues. We keep on the lights. So the lease, Judge, by itself, has so many provisions that, just to point them out to you, but the actual lease was filed by the movants, by the defendants in support of their motion for summary judgment. And the lease has so many provisions about who is responsible for theft, who has to buy insurance for the parking lot, the assumption of risk by the tenants and its employees, or whatever, for whatever happens to their property in the common areas. That's all on the tenant. Basically the landlord is disclaiming almost everything possible. So the evidence is not, as Mr. Hanratty and Mr. Short said, clearly and unequivocally that the control of the parking lot is on Hillside. I think it's clearly the opposite, Judge, is that both have different obligations and right to, exercise the right of control of the parking lot by excluding people. They also are required by lease to enforce the rules, the building rules. The building rules are supposed to be enforced by the tenants, including Conduent. There is a document on the lease itself that says that. And that includes enforcing the non-smoking, smoking only in the designated areas. Outside, and all those different things. So I think that they are asking you, Judge, to make some jumps. The defendants, the movants here are asking you to make some illogical jumps, because the evidence is all to the contrary. So Conduent is the employer. Automatically has a duty towards its employee. Automatically has a duty to protect its employee. And the ingress and egress from the building, this area is used by Conduent for its benefit, right? It wants to give employees breaks. They are not even allowed to leave the premises during the breaks. So they are forced to keep their phones outside of the building. So they are forced to keep their phones in their cars. Then they are not permitted. There is rule by Conduent that they are prohibited from leaving the premises during their breaks, except for the lunch break. And the lunch break, they can quickly go somewhere, maybe to Publix, grab something and easily come back and finish there or eat their food in the parking lot. But this is part of the premises of Conduent. I think all of the record evidence supports that clearly and unequivocally. So generally, even setting aside the whole issue of domestic violence, Judge, there is a duty towards their employee to keep them safe. And so even if there wasn't, to have a special policies in place, or to do something to look for that information, right, to try to find out from their employees, hey, is there any specific threat that we should be aware of? So even if you set that outside for a second, and just consider the fact that the clear and unequivocal and undisputed evidence at this stage is that Shaterica Dawkins did notify Conduent of what happened. That alone, Judge, would require the employer to then consider safety issues as to all of its employees, safety issues for any potential threats that could come inside the building. The guy could have come over and looked for her inside the building. There is restricted access to the building happens only through the non-business hours. During Bill's hours, people can walk in through the lobby, and they cannot go into the actual Conduent suite because they also have an ID tag or something that they have to swipe. But then again, that actually increases the threat. If you have somebody, Judge, who is on a mission to go get one of the employees and to go inside and find them, they will need an ID that everybody wears around their neck. That is another reason why there is a significant threat to their employees, because this crazed guy, against whom a domestic violence injunction petition was filed, against whom an arrest warrant had been issued, a guy police was looking for, who was mad at his ex, who worked at Conduent, and the evidence was, by the way, Judge, that Shaterica Dawkins also told Marcus Moore, and it's a little bit confusing. Marcus Moore believes that it was actually before Elisa was kidnapped. He may be confused about that. But he actually says that she came up to the property before Elisa was kidnapped and talked to him, and expressed to him that she was worried about coming to work, because that's the decision that she made, because he knew where she worked. And also, Marcus Moore testified that, yes, Shaterica as well, I think it was Shaterica, may have been both, but Shaterica testified that Gibson had been to the property many times before dropping her off and picking her up. So she knew that he knew where she worked. That's why, when she went to seek the petition for protection from domestic violence, which I attach a copy of that for the court to review, specifically it lists the address of Conduent at the Hillside building. The petition and the order signed protecting her from domestic violence prohibits Mr. Gibson from going to her place of employment. So if there is forms in place, Judge, this is a completely known risk that, Judge, when you sign an order of protection from domestic violence, you include in that order, and I am sure you have done it hundreds of times, Judge, that the person is not supposed to go to the place of employment. And then for Mr. Hanratty and Mr. Short to seriously argue that this is something completely unexpected, unimaginable, I find that quite strange, Judge. But the fact is this, when it comes to Conduent, I think that the facts are clear and unequivocal that they had notice of the serious incident. And I think it was once they received notice of the incidents, it was upon them to learn more about it, assess the risks and do something about it. When it comes to Hillside, what we have is a landlord that really is a shoddy landlord. A landlord that doesn't really care about safety. A landlord that does informal assessments of security. They don't even have somebody who this is not a baby corporation, Judge. This is not a mom and pop place. This is huge business plaza. A huge plaza where they rent out huge spaces to multinational corporations like Conduent, and they don't do anything about security. They actually do the opposite. They disclaim security. We are not going to provide security guards. We are not going to provide all the different things, you are there at your own risk, people. Good luck. And then what about threats, right? So there. Hope is we are going to put this plaza in a place that's isolated so there is not a big history of crime, even though Tallahassee, Judge, as you know very well, has got a lot of crime, has a huge problem with crime, but whatever. So they put this plaza in some isolated corner of the county that, just not a lot of people live there, so obviously they don't have a lot of crime, and then we are not going to do anything about security. Well, Judge, I am sorry, but if you are a huge landlord, and you are not putting security guards in there that could actually assess real threats, and protect their tenants, their invitees and tenants, and so on and so forth, then how can you not have in place any kind of plan to address the very real potential threat that is a targeted threat that arises from domestic violence situations when you have hundreds of people that work in this place? Hundreds of people. So there is no signs outside. There's no evidence of anything they have done to address this issue. Obviously, if you actually look at the deposition of Mr. Wars, and I attached copies of the relevant portions to you, Judge, Mr. Lewis Wars, who was the security kind of guy here in the Tallahassee branch, he doesn't know what to do when there are security issues. He is, like, when there was an issue with that employee, I guess they put their own employees at risk. There is nobody trained in security, so they, themselves, have to handle the situation, take the guy outside, make sure he leaves before they call the cops.
He was more of an information security person, right?
Yes. Exactly. He was primarily for information security. There is nobody on site. And what he was asked, okay, well, what about physical security of employees? Well, when we know something, what we do is we send an email. We send an email to corporate. That's what they do. They don't say, we send an email, which already said in their lease, we are not doing anything about security. We are not putting security guards in place. We are not putting emergency buttons, or whatever, stations, we are not doing anything. So obviously they are not going to contact Hillside. They contacted Hillside for the lights. That's it. For the things in the lease they say they are going to be doing. So the question is what, so nobody go assess threats that are direct to people who regularly work there. Nobody gets them. Nobody cares. Nobody wants to know. Nobody asks employees, hey, if you know of a particular threat to you, if you have disgruntled X, call this number, whatever. No. Nothing. There is nothing at all, Judge. No security assessments before. And obviously, they still think today that they have no obligations whatsoever to do with respect to security when it comes to personal violence, domestic violence. It's just something that, hey, why should we do anything about it? Judge, I think, yeah, when it comes to Hillside, they have a non-delegable duty to their invitees. There is the special relationship of them being the landlord and Ms. Thompson being an employee of the tenant. Which I think that means that she's, like, the tenant because this is a commercial lease. There is no person, right? So the special relationship, I think, clearly would extend to the employees of the tenants. So you have that special relationship. You have a non-delegable duty to ensure there is security. Then you have a company that does nothing about security, doesn't care about it, doesn't, it's basically relying, so when it comes to security and specific threats, it seems to me that they are relying on Conduent, or the tenants to do whatever they feel is necessary. They are saying, we are not going to do guards. We are not going to put security stations. You tenants handle that. Well, Judge, it is a non-delegable duty. So if they want the tenants to handle it, well, the tenant dropped the ball. And so I think it is a concurrent duty as to both defendants. I think they both dropped the ball. I think that neither one of them wants to face the reality of the significant huge problem that we have in this country, and the world, of domestic violence, and the significant threat to workers from domestic violence. I am going to go through my notes to see if there are any particulars. Judge, do you have any particular questions? You want to go over any particular case, or do you have any particular questions?
No, I don't think so. Thank you, though.
All right. Sure. I want to make sure that you understand, Judge, that the whole argument on notice is not just the issue of the notice that Shaterica Dawkins gave to Ms. Bonnero. There is, on top of that, the separate argument that I am making that an employer, a large employer like this one, we are not talking about no mom and pops. A large employer, multinational corporation and a huge developer landlord, that they should take into consideration when they are assessing security issues, when deciding what security to implement at their premises, they should take into consideration the huge problem of domestic violence, and should have something in place to allow employees to report it, maybe anonymously, or maybe openly, to make sure the employees discriminated against because of reporting potential threats from spouses or from being, the object of somebody's attention. When somebody learns of a threat and they become scared, they should be able to report that to whoever is responsible for security, whether it be the landlord, or whether it be the employer. And if it is the landlord responsible for security, then the landlord should have something in place to communicate with the tenants to say, listen, your employees should report this to us directly, and or you, if you become aware of this, then you should report this to us, and they should address that ahead of time. Like I said, there are model policies out there that people can follow. I don't think you have to have particular case. I mean, you can look at a search throughout the whole nation, Judge, but I think there is extensive information that the courts have about how serious domestic violence is of a threat. We have the, excuse me 1 second. I actually printed, Judge, the Domestic Violence 2017 Bench Book. I mean, that is huge, and it has so much information, resources and stuff about exactly all the threats. And that document also talks about, the issue of the danger going to other places. So it's not just the actual notice from Shaterica Dawkins, but there is also a constructive notice argument as to both Conduent and to Hillside, that they, themselves, should be looking for this information, or should be doing something about it when necessary to protect their employees, their guests, whoever is on the premises. I am just going through my notes, Judge, so just let me go through them.
No problem.
I believe I already addressed this, but one of the arguments Mr. Hanratty says was, number 1, he says that we are supposed to be doing something about this when the actual victim, the target, feels safe at work. And then he also says, and she didn't even recognize that this must have been Gibson. Judge, Ms. Dawkins, a nice young lady, she has a high school education, okay. So she obviously is in shock. She was a victim of a humongous, horrific crime. She, herself, was also raped, kidnapped with her son, probably thought that was the last day of her life. So you are now going to compare the decisions that a huge corporation should be making with what a young lady, who has a high school education, who has been terrorized, who is acting in response, maybe most people would probably think it's irrational, but most people would think Shaterica, knowing he hasn't been arrested yet, should leave the city, okay? So now, just because she made this decision to go to work, we are going to say that the employer also should think this is a safe place. I am sorry, Judge, Purple, that's a very, very weak argument. And the same thing about her not figuring out that there was a connection with the disappearance of Elisa Thompson with Mr. Gibson. Again, she is not a detective. So, obviously, who knows what's in her mind? That's really totally irrelevant what she thinks, or what she thought, and when did she figure it out. But eventually, she got information that it was Mr. Gibson, and actually she helped the cops by providing that information when she learned about a Facebook video that showed Gibson breaking into another household, and showing the car of Elisa Thompson parked outside. And she was found, of course, in the trunk of that car dead. Again, Judge, yes, obviously in hindsight, we know how crazy Mr. Gibson was. Again, I am not saying that this defendant had to know that he was that crazy and that he was going to do exactly what he did. All they had to do was, they know about a guy who's, looking for him. He was a felon at the time. He an arrest warrant against him. He was, in a domestic situation where we've seen too many times in this town of people who have prior history of domestic violence and end up killing their spouse. Barbara Hart is another example, Sandra Frash, I am sure, Judge, there are many more than I have never heard of, It's a horrible problem in this community. And it's not just women. Sometimes the victims are men as well. Regarding the creation of the zone of risk, I think, Judge, if you look at, I think it goes more into whether they breached to the duty or not. But I definitely think that it's very logical to conclude this, that the information that Ms. Dawkins possessed was very valuable and important. She knew who was going after her. She knew that he might come after her in the workplace, so she had ways to at least try to anticipate that and try to protect herself. For example, maybe she would call somebody from work and say, "Hey, come get me outside," or whatever, okay, or she would look in the parking lot first and make sure there is nobody that looks like him around, and then park, and so on and so forth. The fact that nobody was told, several of the witnesses who testified here, including Mr. Roberts, the detective, have said it is very likely that if these people knew, the two witnesses who had seen Gibson on the property, loitering on the property before Elisa even came out of the building, he was seen by others. He was seen by Marcus Moore. He was seen by those two employees. Those two employees actually told Mr. Roberts that they thought he was acting strangely. He was smoking several cigarettes, pacing back and forth. He was out of place. Mr. Marcus also said that he looked like a guy who was out of place. So if they knew, even if they at least informed their employees, we have one of your coworkers has had an issue with an ex. That coworker knows that she works here, and that coworker might be coming here. Give a general description, and say, if you see somebody, report, come back inside and report it immediately. And you may want to skip having your breaks outside until this guy is apprehended. That could have saved Elisa Thompson's life. And everybody that I did not ask all the questions in all the depositions. I know I asked Mr. Robert that, and he agreed. But Mr. Alec Masson, who did the depositions of Marcus Moore. Marcus Moore also agreed, because he also misunderstood. He saw that Elisa Thompson was leaving the property in the passenger side of her vehicle. That it was a black male driving the vehicle. That a black male was driving erratically and almost hit him on the way out. But because of the rash way that they were leaving, and this is his girlfriend, he assumed that something happened to Elisa's daughter, or some kind of emergency, and he went and she left in a hurry with the father of the child because of an emergency. Again, what Marcus Moore thought, he is oblivious to comprehend whether he just saw a crime, that's not relevant, but if he had given information, if he was given information ahead of time, hey, there is a guy who committed a horrific crime, kidnapped and raped, and who might come after one of our co-workers out there. There is arrest warrant against him. He is a felon. Here's what he looks like. So when Marcus Moore saw the suspicious guy, he was later asked that question, would you have done anything different? Yeah, I wouldn't let Elisa just sit there by herself. So just a notice, only notice to their employees probably would have been enough to prevent the horrible tragedy that we have in this case of Elisa Thompson, 26, a college graduate who was going to be pursuing her master's degree, mother of a little boy and a little girl, one of them not even one yet, about to turn one, Judge. She was kidnapped, terrorized, raped and murdered. And he first tried to strangle this lady. That didn't work. He was driving around. Doing what? You know what, of course, looking for Ms. Dawkins. Actually, there is testimony, I think from Mr. Roberts, that some woman using Elisa Thompson's car, he was following the mother of Shaterica Dawkins. And luckily for the mother, the police was contacted and she stopped her and...
Okay. I don't know how relevant that is, and I want to give the defendant some time to reply, so if you could wrap it up please.
I am basically wrapping it up, Judge. This is a horrible crime. It was easily preventable if just two defendants just cared a little bit about their duties. They failed their duty. But this is not what this is about. It's not about establishing liability. It's summary judgment stage, and it should be looked in our favor all the reasonable inferences and the actual evidence that it favors the denial of summary judgment is what the court should consider today, and clearly, we have duty on both of the defendants, so both motions should be denied.
Okay. Thank you. Okay. Mr. Hanratty, do you want to reply?
Yes, Your Honor. Very briefly. Thank you. Plaintiff is again kind of mirroring his written word. He is trying to establish liability, trying to establish that material issues of fact exist by citing and referring to immaterial facts and unsupported theories. He tells the court that, he accurately tells the court that reasonable inferences from the facts can be taken, but what he is trying to do is stack inferences on top of inferences, and that is not permissible. The extent, he seeks to extend his prediction and his prognostication of state of mind witnesses who have testified by talking about the state of mind of the Tallahassee PD detective. He referenced multiple times the words maybe, might be, could be, possibly or probabilities, all of which is nothing but conjecture, Your Honor. If he had any evidence that establishes burden of establishing the exceptions to the general rule of no liability for violent acts, for criminal acts of others, he wouldn't be resorting to arguments regarding the size of the defendants. There is no different duty with regard to defendants based upon their size or their business activities. And when he talks about the special relationship issues, Judge, we have provided you with the case that we cited. It's in tab 9 of our materials, at page 6. And the important thing about the special relationship cases is that they say, and that case states it at page 6, that the defining feature of the cases finding a special relationship under the restatement section 315A is that they all involve situations in which the defendant has a duty to care for the third party who caused the harm. So they claim that we should have had a special relationship now with Mr. Gibson, who is the one who caused the harm in this case. That doesn't make any sense. There is certainly none. He also...
Hold on a second. Is that the Aguila case?
Yes, Your Honor. That's the Aguila case, Aguila versus Hilton, which is an 878 So.2d 392. I quoted from page 6 of the opinion.
Tell me where. I can't see exactly where you are quoting from.
Okay. It's in the materials that we provided. It's page 6. It's the material that looks like under headnote 14.
Okay.
Yep, it's under headnote 14.
Okay. At the very bottom of the page there. I see it. Thank you.
You are welcome. Plaintiff refers to these policies that may or may not have existed, and domestic relations policies that have been cited, and domestic relations handbooks that are not summary judgment evidence and should not be considered by the court. There is no guarantee, although plaintiff seems to argue that there should be, but there is no guarantee under the law in Florida of the safety of employees or even invitees on someone else's property. The law, which is what we are bound by, is that there generally is no duty to protect anyone from the criminal acts of third parties unless there are these exceptions, one of which is constructive notice, which requires, some indication that there is a history or a propensity of violence of the property around them. The complaint doesn't even allege that in this case. So throw that out, and we are left with only the actual notice that brings us back to the kind of stacking of inferences that Conduent should have known that all of this list of horribles was going to happen because one of their employees was involved in a terrible domestic issue with the father of her child. There is just too many leaps of faith, too many stacks of inferences. In this case, for plaintiff to carry their burden in this case. For the arguments that we raised in our briefing and that which we argued today, we urge the court to grant summary judgment because the plaintiff has utterly failed to meet its burden to provide evidence, material evidence of any of the exceptions to the general rule as quoted earlier. Thank you, Your Honor.
Okay. Thank you. Mr. Short.
Yes, Your Honor. Very briefly. Mr. Wachowski raised several issues in his argument that the crime in Tallahassee, domestic violence crisis across the country, handbooks, policies from Ivy League institutions. As Mr. Hanratty pointed out, none of that is the issue before the court today. None of that is related to these issues. That is all editorialization's extra non-record evidence. Mr. Wachowski, plaintiff's counsel, has alleged that Hillside is a shoddy landlord, and that they don't provide any security. Well, he has pointed to the provisions of the lease, and has asked the court to take notice of the entirety of those provisions, and has said that in those lease provisions, Hillside disclaims any duty to provide any security, to provide any measures. We are throwing our hands up and we are doing nothing, and we are just asking these people to protect themselves. Well, that's not true. The provision in the lease says that Hillside will not provide any additional security measures outside of what is required for it to comply with the provisions of Florida law. And what Florida law asks Hillside to do is to protect business invitees from foreseeable risk. This is not a foreseeable risk. Just because there are analogous cases in North Carolina, or other parts of the country, does not make this a foreseeable risk. And that's what this comes down to. As mentioned previously, there is no knowledge by Hillside, either constructed or actual, that there was a threat to anybody at the premises. Mr. Wachowski has asked that we should do something to make sure employees aren't discriminated against, and to do something about the domestic violence problem. Well, ideally, that would be great, and that would be something that, we would never have these domestic violence problems lead into the workplace. Unfortunately, there is no foreseeability. There is nothing to be done, and Florida law doesn't prescribe that there is a duty to do so for a landlord, or for a business occupant. And so this is asking the court to go outside the bounds of Florida law, asking to prescribe an additional duty that is not allowed under Florida law, is not prescribed under Florida law to landlords and to business owners. And for those reasons, we believe that summary judgment is appropriate, and we ask the court to enter an order reflecting the same.
Okay. Thank you. Okay. So based on everything presented...
May I respond?
No. I usually just let the movement reply, and then we are done with the argument. And I gave you a lot of time also, Mr. Wachowski, so I am not going to let you respond. So based on everything in the filings, as well as the oral argument that was printed today, there is absolutely no evidence of any prior crimes at the premises. It's not a high crime area, or a rankers bar or festival like the Bushwhacker Festival that was discussed in one of the cases. There is some evidence that Dawkins disclosed some of the information about the incident that she had with Mr. Gibson on November 27 of 2018, which, of course, was miles away from the premises that's involved in this case. Her incident with Mr. Gibson occurred on November 27, and she testified, although the employee disputes it, but Ms. Dawkins testified that she disclosed to Ms. Rowe some information about a kidnapping by Mr. Gibson, but it was in the context of her wanting to discontinue remote working, and in the context of how she was going to be working, not any type of warning about Mr. Gibson, who Dawkins even said she didn't think was capable of murder, and was shocked when she found out about the incident that occurred that began with the kidnapping of Ms. Thompson, that started around noon on the 29th, the following day. So I am going to find that there is no notice, constructive or otherwise, to the two defendants, and that there is no duty on their part to prevent an incident like this that's totally unforeseeable, and not within the zone of risk as defined by Florida law. Again, it's not a high crime area. There is absolutely no evidence of other crimes occurring in this office complex, or anywhere near it. Although, in hindsight, A couple of the employees thought Mr. Gibson looked suspicious when he got into Ms. Thompson's car about 100 to 120 feet away from the back door of the business. Conduent. An investigator Roberts is the one that gave that distance estimate when he was talking about a map and the lawyers were asking him questions during his deposition. A couple of the employees thought he looked a little suspicious, but there wasn't any yelling or arguing, and they didn't think enough of it to call 911 or anything. And I agree that the plaintiff is asking the court to stack numerous inferences about domestic violence cases generally, and violence in Tallahassee, and imputing that to somehow get to the requirement of duty and foreseeability, which just is not here based on the undisputed facts. So I am going to grant both motions for summary judgment, and I am going to rely on the defendants to prepare the orders. And I guess let's do separate orders from you two gentlemen. And of course, let Mr. Waxevsky take a look at those before you submit those to my assistant. Okay. Thank you all.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Bye-bye.
So what do you think? Should employers take proactive measures to learn about directed, targeted threats to their employees? And do you think that those targeted threats could pose a danger to other people, not just the specific target, but other people working in the workplace? For example, people that may want to interfere and save the real target of the threats. Thanks for watching. Mentor Lawyer.
Thanks for watching this video, and shout out to Aaron Nola Raised.
Thank you so much, Aaron, for all your support.